Welcome to Judge the Judges, Judicial Candidates Forum. And I'm your guide tonight. My name is Tanya Ba. I want to thank you so much for coming out virtually. You can call me T-Ba. And I just want to mention, if you haven't had a chance, go ahead and put your name, your pronoun, and your Philadelphia neighborhood in the chat. And I want to remind people that the forum is being recorded. So if you're not interested in being recorded, go ahead and turn your camera off. Now, for Twitter, you're going to use the following handles and hashtags: at Judge Our Judges, at Phila Courts, hashtag Philly Judges, hashtag Philly Primary 2021. And please mute yourself if you are not a speaker. So tonight we're going to hear from judicial candidates running for the Court of Common Pleas and for municipal court. There are 8 seats open for a Court of Common Pleas, and the 17 candidates running for those 8 seats are Caroline Turner, Terry Booker, Wendy Barish, Craig Levin, Kateria McCabe, Sherry Cohen, Nick Kamal, Patrick Moran, Dan Solomon, Maurice Houston, Betsy Wall, Michelle Hangley, Richard Cataldi, John Padova, Chris Hall, Mark Moore, and Tamika Washington. The 5 candidates running for the 3 open seats in municipal court are Michael Lambert, Barbara Thompson, George Twardy, Sherry Cohen, and Greg Yorgi Gertie. Now, I want to make sure you understand that the Judge Accountability Table has organized this 2-day forum because we know how important public education is in these low information races. So in order to have a Philadelphia where people are not imprisoned due to poverty, we need to know who selects who. Did you know that the municipal court judges are the ones that appoint the arraignment court magistrates? The majority of the over 4,000 people sitting in Philadelphia jails today are there because they can't pay the bills set by the magistrates. The Judges Forum helps community members understand who they're putting in charge of our courts for the next 10 years. Who will determine if we go deeper into mass incarceration or if we finally move towards freedom and liberation and away from racism and adversity? The Judge Accountability Table is a C3 coalition and does not do endorsements. Today's forum is for public education purposes. Now, some community guidelines. If you are not speaking, please be sure to keep yourself on mute so that we can hear the speakers. We've got a Zoomologist who will kindly mute folks. There are a lot of people here today with different opinions, so be sure to keep the language in the chat respectful. And today's forum, again, is being recorded, so if you do not want to be recorded, kindly turn off your camera. The judicial candidates are encouraged to share their campaign website and social media platforms in the chat. Please refrain from spamming the chat. So here to give us our candidate instructions is Nikki Grant, our Court Watch Coordinator and amazing organizer for Amistad Law Project.
All right, good evening, everyone. Good evening, candidates. So I'm going to read this here and I'm going to ask you to respond. In the interest of fairness and honesty, do you pledge to the voters of Philadelphia that you will participate in this forum in good faith? In an email sent on Monday, you were instructed to not watch the March 30th portion of this candidates forum, nor be advised by anyone who watched it. Did you follow this instruction? And you might have your yes to no signs. You can go ahead and use those to respond.
Okay. If I call your name, you can go ahead and put your form down. Okay. We have a no with Caroline Turner, a no with Rainier Major, a no with Maurice Houston, a no with Judge George Twardy. Dan Solomon, I want to see what you have. There's a yes. We've got a yes with Mark Moore. And did I miss anyone?
I think a candidate just entered the chat or the forum, so I can read the question again.
Okay. Maurice, this is the time for you to answer yes or no. We're going to have an open dialogue opportunity a little later. So do you not have your card? You're muted, but you can go ahead and put that yes or no up at this time. It looks like you have a yes. Thank you very much. And so did we have another candidate that we had missed? If they could put their card up now, please. Can someone let me know who that is?
I'm not sure if you're referring to me. This is Kateria McCabe.
Yes. So Ms. McCabe, would you please put that up now?
Put up, wait, I'm sorry, I did not hear the question.
Yeah, I was like, you missed the question. So the question was, in the interest of fairness and honesty, do you pledge to the voters of Philadelphia that you will participate in this forum in good faith? In an email sent on Monday, you were instructed to not watch the March 30th portion of the Judicial Candidates Forum, nor be advised by anyone who watched it. Did you follow this instruction?
Thank you. And that's a yes from Kateria McCabe. Thank you very much. I appreciate it.
My pleasure.
Later on, we'll ask the people who said no to go ahead and give us an explanation for that. Thank you.
Can I just interrupt? This is George Twardy.
Unfortunately, we're going to have to mute you because right now you're to answer yes or no, and there will be an opportunity later on to actually be specific. So we have a yes for George Twardy. Thank you. So the candidates for day 2, I think that I have read out, but I'm going to just read it again. The candidates for day 2 would be Caroline Turner, Dan Solomon, George Twardy, Mark Moore, Maurice Houston, Rainier Major, Tamika Washington, Terry Booker, and Kateria McCabe. And now we're going to hear some political education at this time. This will be from Karima McCleary from Free the Ballot.
Hi, thank you, Tiba. I want to thank all the candidates that came out today. Okay, my education I want to give that there are 451 judges that's in the Pennsylvania Court of Common Pleas. They're divided by the districts and they must all be lawyers and they're elected for 10 years. I'm sorry, yeah, for 10-year terms. Okay, the Court of Common Pleas is where most of the misdemeanors and all felony criminal cases are heard. The Court of Common Pleas also address the orphan court matters and where larger civil cases originate. They also reside over family court cases such as adoption, divorce, child custody, child support, abuse, and neglect, and are addressed at the primary level under the supervision of the Court of Common Pleas, as well as appeals from government agencies such as zoning and other municipal appeals and appeals from district courts. Now I just want to share my screen for a second. Hopefully I can find it. And okay. So this is just a little diagram that I found on the Court of Common Pleas. I'm sorry, on the whole Pennsylvania court system. So it shows that you have the minor courts here, and then right here is where the Court of Common Pleas preside over their cases. And then any appeals or anything goes up to the Superior Court. It's divided into the Superior Court and the Commonwealth Court, and then at the top you have Pennsylvania Supreme Court. So that's my little thing here. I'm sorry. Okay. I just want to go on, in conclusion, I was asked to explain why it's important for people to know the power of common plea judges and why it's important for them to vote. The common plea judges, they have a lot of power, believe it or not. If a person is accused or charged with a crime, the judge of common pleas has the authority to decide whether they go to jail or are they just given a fine. The judge can set a high bail, and if they, of course, can't come up with the money, then they go to jail. Or are they just given a fine? I'm sorry. The judge gets to determine whether things move forward or whether they stop. They can decide whether to submit evidence or whether the police acted within their rights. Did they even have a warrant to arrest that person? And in domestic violence cases, the judge can determine whether a PFA, which is a protection from abuse order, what has been violated. And all of this consequently can affect the safety of a person and or their family. So a lot of people just feel like, they just want to vote in the presidential election or the big elections or something like that. And a lot of times they don't even know who these people are. They just see a name. That's why we have these forums, so that we can meet the judges, see what their ideas are. And just, we wanted to let you guys know that that the Court of Common Pleas Georgia judges are very important. That's it. Thank you, guys.
Thank you, Karima. We're going back to Nikki Grant. Nikki.
All right, so I think we're doing the yes, no questions now. So the criminal legal system in this country ensnares people of all races and socioeconomic backgrounds, but it disproportionately impacts poor people, Black people, and other people of color. At Amistad Law Project, we work with many people who are serving life without parole sentences, or as we call it, death by incarceration. People serving death by incarceration and their loved ones have a stake in judicial races because they have been caught in this punitive system, some for decades. In the city of Philadelphia, we are slowly starting to learn that we cannot incarcerate our way to safety. The murder of Walter Wallace Jr. in my West Philadelphia neighborhood tragically showed us that the only resource our communities have been given in abundance is police. The answer to how we make our communities safer, how we reduce the homicide rate, how we help our communities heal, is not more cops, pretrial detention, and long prison sentences, but defunding the police and giving our communities the resources they need to thrive.
Hey,
My
Nikki.
question for the candidates is, do you believe anyone should be jailed because they are poor?
Okay, please keep your signs up until I say your name. Caroline Turner has a no. Rainier Major has no. Maurice Houston has no. George Twardy has no. Dan Solomon has no. Tamika Washington has no. Mark Moore has no. And Kateria McCabe has no. Dan Solomon has no. And you can take your sign down, please. Now, before we move, did I leave anyone else out? Because I know that we don't always have space on the screen for everyone. Looks like we got all.
T-Bon, just a quick thing. Actually, if this was for Nikki to finish the, what is it, the affirmation about whether or not folks follow the instructions. Sorry, Nikki, that was confusion. Because we didn't get to give folks a 30-second just like explanation for the folks that answered no. So this is a little bit of confusion, but like Nikki, I know you just asked the first question, but it was actually to just finish up that other one because some candidates had answered no about following the instructions. So I'll send it back. Can we send it back to Nikki? T-Bon, is that all right?
Yes.
Yeah,
Nikki,
because it was all finishing that up. Yeah.
No worries. Okay. So there were a few candidates who I believe answered no, and those people were
have them hold their sign back up if they didn't follow the instructions. So we have Caroline Turner, Rainier Major, that said no. It looks like Tamika Washington is trying to hold up no. And Nikki?
I think Mark
Mark
Moore
Moore.
also says no. All right, so we'll just go by who's on my screen. So Caroline Turner, you have 30 seconds to tell us how and why you didn't follow the instructions.
Yes, this is what happens when you don't read your entire email with the invitation. I didn't get to the bottom part where it said I wasn't supposed to go online. And I got a phone call last night at 7:30 from someone who said, why aren't you on the JAT? And I said, because I'm going tomorrow. And he said, well, jump on, it's on Facebook. So I jumped on and just got the tail end of it. And then I read the whole email. So I felt terrible. I phoned Rebecca instantly, apologized profusely, but that is what happened.
All right, thank you. Vanna Major.
Good evening. So I didn't see the instructions. It went to my team email, and I read them tonight when I was getting ready for the link. I did hear just the last question and the last set of answers because I was otherwise engaged last night anyway.
Okay, thank you.
Sorry. And I do need to cut out for a little bit at around 7, but I'll be back.
Okay.
We had
Let's-
2 more no's. Who were the other 2 that had a no up? Please bring your no back up or show yourself on the screen and unmute yourself.
I had more, but I no longer see him on my screen. Oh. And he had to leave. Okay. And
And
there's one more person. Oh, yes, Tamika Washington.
No, I answered yes. For the
Okay.
first question,
about the
Where-
instructions.
where for the instructions, I
Yeah.
answered yes. I followed the instructions. I
Okay,
have not had any contact with anybody that was on the forum last night or logged into any portion of the judicial forum last night.
Thank you. Okay. Nikki, you satisfied with that?
guess so. All right, back to you.
Okay, so we are about to move into values and campaign questions. Again, we're going to ask you to hold up your yes and no answer in front of the camera until I actually call your name and we have recorded your answer out loud. This first values and campaign question will come from Karima McCleary, again from Free the Ballot. Karima?
Yes, thank you, T-Bot. My question is to the judges, would any of you commit to refuse to accept campaign donations from any police-backed organization or political action committees?
We have a yes with Caroline Turner, a yes with Rainier Major, a yes with Maurice Houston, yes with George Twardy, yes, Dan Solomon, no from Tamika Washington. Okay, and unfortunately I did, and a yes from Kateria McCabe. Thank you. So I believe we're going to take 30 seconds to allow anyone that had answered no to explain why it's no. Tamika Washington, did you want to take your 30 seconds to share?
Hello, good afternoon.
Good afternoon.
Good afternoon. So indeed, while we have a system, we have a criminal system that is broken. Indeed, we have a system wherein we have people who are wrongfully jailed every single day. However, that does not necessarily speak to whether or not a candidate can have support from the police or not from the police. That is not necessarily, those two items are different. And at the end of the day, a judicial candidate cannot make any promises. A judicial candidate must make sure that everyone who walks before his or her courtroom is given a fair trial without regard to the group that the person belongs to, whether it's a labor union, whether it is any group that could potentially support a political candidate. So therefore, I cannot necessarily say, oh, absolutely not, that I would not receive any support from a police-backed entity, because at the end of the day, I have to close the door of my courtroom. In the event that I'm successful, I have to close the door of my courtroom and make sure that the parties that appear before me receive a fair trial.
Thank you, Tamika Washington. For clarity's sake, Karima, could you repeat what that question was again?
Yes, ma'am. I have, will you commit to refuse to accept campaign donations from any police-backed organization or political action committee?
Thank you. Okay, so we're moving on to jury nullification. And that question is coming from JT from the Abolitionist Law Center. JT, you are up.
Can you hear me?
I can.
Can everybody hear me? Hold up, something's wrong. Give me a second.
No, we hear you, John.
Oh, I was thinking that you couldn't hear me. Hello, everybody. My name is John Thompson. I'm an organizer for ALC. And I just want to thank everybody first and foremost for coming out tonight and being here and being a part of this. I'm an organizer, like I said, I'm an organizer for ALC. And the reason why I organize for mass liberation is because I was incarcerated for over 37 years. I have endured the pain and suffering of being locked in a cage, being locked in a cage, the degradation of having to strip and to strip every time you want to go on a visit to see your loved ones. And being released from prison does not mean that I could be a normal member of society, because I still have the label of being an ex-felon, being supervised by the same people who not only support mass incarceration, but are part of the institutional racism that continues to fuel mass incarceration. Every day I have to deal with the pain and the mental trauma that we suffer in prison, and the fact that millions of Black and brown men and women are still suffering. There are many days when I feel like I'm still incarcerated. There are many days when I feel like I'm still incarcerated. So I organize for mass liberation because of my brothers and sisters who are still incarcerated. One of the things that pushes me forward is the fact that I left a lot of my brothers and sisters behind who could be productive members of society. And I think that it's my duty to organize around mass liberation. So with that being said, the question for nullification is, do you agree that jurors cannot be punished in any way for their verdict they reach in a criminal case? Excuse me, mind you, this is a two-part question. That is the first part.
Okay, right now we're going to ask, again, the candidates hold up yes or no on your answer sheet in front of the camera until your name has been called and your answer has been recorded out loud. And please do that now. At this time, I have a yes from Caroline Turner.
Can John repeat the question for me?
Yes, actually, we certainly can.
Sure, I can repeat the question and I'll read it slower. Do you agree that jurors cannot be punished in any way for the verdict they reach in a criminal case?
Okay, we'll start this again. Caroline Turner is a yes. Raina Major is a yes. Thank you. Maurice Houston is a yes. George Twardy is a yes. Dan Stolman is a yes. Tamika Washington is a yes. And Kateria McCabe is a yes. Thank you, John. I just want to hear the question one more time. We did have all yes.
The first part of the question was, do you agree that jurors cannot be punished in any way for the verdict that they reach in a criminal case. That was part one. That was the first part.
Okay.
And thus jurors have the right to acquit defendants for any reasons, including the juror's belief that the law the defendant is charged with violating is unjust.
Okay, at this time, if you could raise up your answer of yes or no, and we can certainly repeat the question again while you're doing that, John, please. The second half of that question.
The question is, and thus jurors have the right to acquit defendants for any reason, including jurors' belief that the law the defendant is charged with violating is unjust. Meaning that they can acquit for if they think that the law is unjust.
We have a yes from Caroline Turner, a yes from Raina Major, a yes from Maurice Houston, a yes from George Twardy, a yes from Dan Solomon, and I'm trying to see Tamika Washington. I believe it is a no, and a no from Kateria McCabe. Okay, at this time, we are going to allow you to speak during the open-ended portion of the program, but we're going to move on to the next question.
T-Bob,
Yes.
the question wasn't finished. That was my mistake. It wasn't done.
Okay,
May I interject?
let's make it right.
Right. And the last part of the question is, do you commit to instruct jurors in your courtroom on the right to acquit for any reason the jurors deem just? Again, do you commit to instruct jurors in your courtroom on the right to acquit for any reason the juror deems just?
Okay. Caroline Turner is a no. Raina Major is a no. Maurice Houston is a no. George Twardy is a no. Dan Solomons a no. Tamika Washington is no. Kateria McCabe is no. Thank you, John. Thank you, judge candidates. We will move to our immigration question from Lisa Klinman from ICE Out of Courts. Lisa, you are on. Lisa.
Hi, thank you. Yeah, good evening. So I'm asking a question on behalf of the ICE Out of Courts Coalition. I work as an advocate supporting immigrant survivors of harm and violence and accessing medical and legal services that they need to heal. Immigrant survivors of violence face huge barriers in accessing court and other institutional systems, which can be terrifying and re-traumatizing, particularly for individuals without documented status, because there is no guarantee that ICE agents won't kidnap them on their way to and from court or kidnap family or community members who support and accompany them. So this means that every time a survivor who is not a citizen goes to court, they're risking deportation, family separation, and even more violence in order to just attend. Similarly, individuals who attend court as defendants and their families are even more at risk of deportation by ICE going to and from court, which denies everyone involved due process. This isn't justice. So my question for you is, will you support the courts in instituting a uniform policy prohibiting court personnel from contracting ICE, which is Immigration and Customs Enforcement, and discouraging ICE arrests on court property without a judicially signed warrant?
Okay, so Lisa, thank you. I see these yeses across the screen right now. I'm going to read off. Caroline Turner is a yes. Raina Major is a yes. Maurice Houston is a yes. George Twardy is a yes. Dan Solomon is yes. Tamika Washington is yes. And Kateria McCabe is also yes. Thank you. Thank you for your responses. Now we're gonna hear from Nikki Grant again because we love her voice, and this question is Bell.
Yes, so I'll give the short version of my question.
Thank you, Nikki.
Do you believe anyone should be jailed because they are poor?
Nikki, could you repeat that one a little louder, please?
Do you believe anyone should be jailed because they are poor?
Okay. Caroline Turner is a no. Raina Major says no. Maurice Houston also says no. And George Twardy, hold yours up just a little higher for me. That's a no from George Twardy. Dan Solomon says no. Tamika Washington says no. Kateria McCabe says no. Nikki, repeat the question that everyone said no to.
Do you believe anyone should be jailed because they are poor?
And the answer was no. It was unanimous. Thank you, Nikki. Okay, so we are moving on to the section of open-ended questions. So again, the candidates for day 2, Caroline Turner, Dan Solomon, George Twardy, Mark Moore, Maurice Houston, Rainier Major, Tamika Washington, Terry Booker, Kateria McCabe. Okay, you're going to have 2 minutes each to give your response for the following questions. You're going to get a 10-second warning before your time is up. But if you continue to speak, you will be muted. The first question, this is going to be from Nisha Cooper from the Philadelphia Community Bail Fund, and this is around bail. Nisha, thank you. You can ask your question now. Okay. And while we're waiting for Nisha, we're going to move on to the next.
Actually, Tiba, I can just, I'm not sure I saw Nisha get in, but we'll ask the question still because it's important to make sure that we ask this question. Is that cool? Because I don't see that Nishay's in the chat.
Thank you,
Tiba. All right, so the first question that we're asking, which is an open-ended question. Just give me a moment. So the first question is, you all just answered no to the question about anyone being jailed because they are poor. Will you commit to eliminating cash bail in your courtroom? If so, how?
Okay, so you're going to have time now to answer this question. 2 minutes. I'm going to call your name, Caroline Turner. Please unmute yourself and answer.
Thank you so much. Yes, I commit to getting rid of cash bail in my courtroom. There are many factors to consider when you're considering a person's freedom. It's not just the crime that has allegedly been committed. And let's not forget that at that point, somebody is legally innocent. We are instructed by our Supreme Court, it is one of the bail factors is the ability to pay of a defendant. There has to be a hearing about ability to pay if anyone was going to set bail. That is regularly not happening. And we are to consider so many things like whether somebody has a job, whether they have ties to the community, whether they have failed to appear in court before, whether they are going to lose their home and their job by going to jail. We are to consider the crime and also the likelihood of conviction, whether there's enough evidence to convict this person, because so many people are kept in jail without there being even enough evidence to commit them of the crime. We know too that crimes are stacked. People have charges that are much higher than the basic charge that they have put on them just because police officers in charging documents can do that. So we have to look at the whole person. We have to look at every single thing about the person, not just the crime charged, but their ties to the community, their everything about them. And we finally have to make sure that nobody is detained because they can't afford to get out. So yes, I commit to getting rid of cash bail in my courtroom.
Thank you, Caroline Turner. We just heard from Caroline Turner, and thank you very much. Dan Solomon, what say you?
Okay, good evening. That's a good question. I would first say that there are factors that are prescribed by the law, the legislature, regarding how to set bail, if bail is warranted at all, and every court should address those properly and use common sense and reason. People should not be languishing awaiting trial because they can't muster cash bail. we've seen too many consequences of that. These results in people pleading out because they want to get out, people losing their job because they're detained for days before they can raise the money. And, you know, study after study has shown that cash bail is really not any more effective in making people show up to their trial dates. So it's important to understand those issues around bail. What I won't do is commit to making a decision in any case before I hear all the facts and evidence and review the law. So I cannot commit 100% to a matter that might come before me because that would violate the Code of Judicial Conduct, and I'm unwilling to do that. And if I would violate the Code of Judicial Conduct, I would be removed from office and or disciplined at minimum. So that I won't commit to that. But I do understand the issues and understanding that there are other ways to make sure people come to trial, other ways to make sure trials are handled promptly and disposed of promptly so that people aren't languishing.
Okay, thank you, Dan Solomon. We just heard from Dan Solomon. Thank you very much. Same question for George Twardy.
Yes, good evening. I've been an attorney for over 30 years and represented people in the criminal courts many times over my career. And I can tell you that I don't think that there was any client that I ever had that didn't show up for court. And it had realistically nothing to do with his bail. Bail's supposed to be about the major reason for bail is that to assure that the person's presence in the court proceeding and that they will show up and that and they won't flee. We have to get back to our founding principles that people are innocent until proven guilty. Many times as a defense attorney representing a client who was charged and facing bail, the prosecution's biggest argument is look at the gravamen of the charge. It's just an allegation and a charge at this point. Certainly there are community issues and safety issues, but we could look at things like electronic monitoring and things like that if we don't want someone to flee the jurisdiction or appear in court. And I think just like Judge Sullivan said that money and bail is not necessarily the best avenue to do that. So I am not a proponent of sticking people with heavy bail penalties, which would keep them incarcerated pending their day in court.
10 seconds.
Thank you, George Twardy. That was George Twardy. We just got that answer from. We appreciate it. Next would be Mark Moore. Would you please answer the same question? Mark Moore.
I think he had to leave.
Okay, thank you. So Maurice Houston. Maurice, would you answer that question for us now?
Thank you for having me this evening. And thank you to all the other participants on the panel. I'm a believer that bail should be non-excessive and it should be reasonable. If we take a cue from the federal system, cash bail is something that they have moved away from. We have alternatives to bail, and I talked about those during the questionnaire that I turned in. But it's important to remember that if you're asking someone to pay bail, it has to be reasonable. So one of the things that I realized back in 7th grade, I watched a film and it talked about bail. It talked about the ability of someone to pay bail. And we've been answering questions about a two-tiered system here tonight. And no one should be incarcerated just because they're brought up on charges because they don't have the money. If you say to someone who is a millionaire, your bail is $10,000, they can go ahead and make that. But if you say to someone who is low income that doesn't have any money, $50 is too much. $50 is considered non-reasonable. So we have other alternatives to cash bail, and that's what I'm committed to offering to individuals who qualify. Keep in mind that individuals that come before the court, they were just charged with allegations. They are still innocent. And we recognize through all of the studies that if an individual is not incarcerated, there's a high likelihood that they're able to participate in their defense in a meaningful way. And therefore, when someone is incarcerated, it's more likely than not, especially if it's a petty charge, that time will go past in the system. And that at the end of the day, there's a possibility they're going to accept the plea just because they couldn't make bail. We know the ramifications of someone being incarcerated while trying to sit and make bail. So I'm committed to following the law. I'm committed to saying, hey, we have alternatives to cash bail, and that's where we need to move. So alternatives to cash bail, house arrest, electronic monitoring.
Maurice Houston, we thank you so much for your answer. Thank you very much. That was Maurice Houston. Okay, Rainier Major, same question.
Good evening, I'm Rania Major.
Thank you.
You're welcome. It's real, Rania, whatever you want. Either of those two preferably, but thank you. First of all, I'm running for municipal court, which means that I'm the first stop as a judge for most people to see after they've seen a magistrate concerning bail. And I say most people because in the bail courtroom preliminary arraignments, you can appeal and then the emergency judge can make a decision if you don't like your bail. But so I would be the first stop after that. As an attorney for 33 years and a criminal defense attorney with the nickname Pitbull Lawyer, I am very concerned about bail. I do not support cash bail in all circumstances. And I demarcate. I cannot say, for example, that all non-violent cases would have no cash bail. I can tell you that when it comes to violent, let's say a rape case, a repeat rape offender that's accused again, you still need to take into account all of the elements that are required, some of which you've heard from some of the other candidates tonight. What's the nature of the charges? Yes, there's a presumption of innocence, okay? And no doubt we have eradicated it and it's time to put that back on the bench, okay? But you have to look at that, the harm to the community. COVID has brought in more ankle bracelets. Why not house arrest? Why not some form, especially for lower level crimes, help them find a job while they're out? So I can't commit 100% to no cash bail because it depends on some of the felonies. But for lower level crimes, I think that it's more than reasonable to do away with it or make it comport to what the person can afford.
Rania Major, thank you so much. Thank you for helping me with your name as well. And thank you for your answer. That was Rania Major. And Tamika Washington. Tamika Washington, please, same question.
Thank you. I have represented clients who have lost their homes because they were incarcerated or because they were waiting for court to occur. I've represented people who have been waiting in custody for a year. However, I would say that you have to look at each case circumstances. You must look at, does that person have community support? Does that person have, for example, a home that they may lose if they sit in jail for 8 months to a year? What can that person afford? So and this has been touched on by some of the other candidates, but what are the circumstances of each case? What is the nature of the crime? And you cannot just say, I cannot agree to just obliterate cash bail completely, because indeed, if you have a serious matter where the person is accused of murder, where the person is accused of rape, there could be a potential threat to the community, then we have to implement those guidelines with cash bail. However, we have to look at the circumstances of the case. If we've seen that other courts have done away with cash bail, then we should take a look at each case and make sure that we're not rubber stamping each case with cash bail. Thank you.
Tamika Washington, thank you very much. That was Tamika Washington we just heard from around the question, will you commit to eliminating cash bail in your courtroom? Terry Booker, who I'm not sure, but I don't believe Terry Booker.
Terry Booker's not here today.
Thank you. So Kateria McCabe.
Good evening. Good evening.
Thank you.
And so I'm similarly situated to, I'm currently a judge in family court, similarly situated to the response that was given by Judge Solomon. However, I will say that you must look at each case according to the facts that are presented. We know Philadelphia has the dubious distinction of being the poorest of the big cities. We also know that cash bail disparately impacts the poor, Black and brown people. And when I say look at the facts of the case, you also have to look at the facts that are presented. What are the community ties? What is the person's financial circumstance? We know that people lose housing, they lose jobs, they lose custody of their children because they may be sitting in jail for what to them is a lot of money, and maybe to somebody else is just a couple of dollars. But if you can't afford it, you can't afford it. And so you must look at all of the factors so that you're fair. Unfortunately, what happens is we have what's currently in place is a punitive system before someone has even been found guilty. And so we have to look at the fact that we are in a system where you're supposed to be innocent until proven guilty. And the cash bail system, unfortunately, can impact someone as if they've already had a full hearing and been tried, and that's not the case when you're at the preliminary arraignment stage.
Thank you, Kateria McCabe. That was Kateria McCabe with the last question that we asked. Will you commit to eliminating cash bail in your courtroom? And if so, how? So the next question, Jamie Sullivan from 215 People's Alliance. This question will deal with incarceration. Jamie Sullivan, you are up next.
Thanks so much. Hi all. Thanks everyone for organizing this. My name is Jamie Sullivan. As she just said, I use she, her pronouns. I'm representing 215 PA or People's Alliance. My question has to do with probation and parole. So just to talk a little bit about how this personally affects me, I haven't experienced probation or parole myself, but the younger generation of my cousins, I'm an only child, and I'm been very kind of my vicarious children have been through my cousins who I grew up with. And of the 8 kids who range in ages from 4 to 22 now, half of them have experienced incarceration as children and have also dealt with parole and probation as children or while they were newly 18. And as probably most people know, time seems to pass faster the older you get. So a small amount of probation or parole to an 18-year-old can feel like an eternity. So one of the more recent conversations I had with my cousin who I babysat when he was a toddler, and due to difficulties in the family, I thought that things might come up with him later in life. It's a longer story than we have time for, but when I was talking to him when he was about to be released just after he turned 18, he was going to be on probation for 5 years, and trying to talk to an 18-year-old about how 5 years isn't that long, it's not. I mean, I felt like I wasn't being honest. 5 years is a really long time for an adult. And I was just trying to figure out how to tell him that he could get through it and how to support him in getting through that. So to move, I could talk about that for longer, but to go ahead and move on to my question. According to the Philadelphia Inquirer, 1 in 23 adults in Philadelphia is on probation or parole, the highest rate of any big city. Pennsylvania is also one of the leading states in long probation tails, sentencing many people to 10 years or more after a jail sentence. What would you do to curb Philadelphia's problem with mass supervision?
Thank you, Jamie. Thank you. Okay, so we are going to start with Caroline Turner. With that question, Caroline, please let me know if you need the question repeated.
Caroline, you're muted.
Can you hear me now?
Yes.
Okay. I'll start again then. We have a huge problem with probation in Philadelphia. We have a multitude of people who are on probation for 10 to 20 years at a time. And it's really sad that through juvenile court, it seems to be a gateway for people to be getting put on probation for municipal court cases. And they get violated for technical violations such as not being able to log on to school, either because they can't get a good internet connection or sharing a laptop with other members of their family, things like that. And in the adult system, it's the same. There are numerous technical violations of probation. A technical violation is when you haven't committed a new crime. You've gone across the bridge to New Jersey to pick up your kids or something without your probation officer's permission. And it's just, everyone feels like they are a heartbeat away from a technical violation of probation. I would put a cap of 3 years on probation because statistics show that if you're going to fail out of probation, 70% do so by the end of the second year and 90% by the end of the third year. So that is the optimum period of probation. These long probation tails and long probation terms set people up to fail. They do not set them up to succeed. We need to let people do their time, come home, and succeed by providing community support and resources, and not by continually surveilling them as a Commonwealth. I can't see everybody. Can people see me?
Yes.
Oh, good, I can now. So I think my time might be up. I could go on about probation. I feel very strongly about it, but I would definitely put a cap of 3 years on it. And support people when they come back from prison, support people in the juvenile system, help them not to get technical violations, and no lengthy terms.
Thank you, Caroline Turner. That was Caroline Turner answering our question around probation. And Dan Solomon, you are up next. Dan, please.
Okay, thank you for the question. I'll say that, first of all, criminal sentences are typically set by the Pennsylvania General Assembly, which is out of the purview of the courts. What I will say is Pennsylvania has a real problem with lengthy probationary terms, lengthy, very difficult parole provisions that where people are, as was stated before, are really set up to fail. So, and then they're in a sort of a vicious cycle of awaiting, the next shoe to drop. And that's not a way that people can proceed in life. Studies again have shown that, the shorter the probationary term might be, if the case warrants that, then the more successful that that individual will complete probation. Secondly, so the court has to use common sense. We've heard cases in the news, and one was in the news for a while. It was a low-level case that resulted in a conviction, and 10 years later, this probation wasn't over yet. And that just didn't happen to that person. That happened to thousands upon thousands upon thousands of people all across Pennsylvania. So you can't have these lengthy terms because that's never going to work. It will be a cycle of in and out of prison. Secondly, we have people being violated for marijuana. Well, marijuana is legal in a lot of states. So we have these difficult people getting caught in what are very minor violations. You can't have that. The goal is to have the sentence completed promptly so that people can move on in life. And lengthy probationary sentences do not allow for that. So the judge should use discretion as allocated by the law and the facts of that case to use common sense and make a reasonable decision and not set up a defendant who has been convicted for failure.
Dan Solomon, thank you very much for answering that question. That was Dan Solomon answering that. Rania Major, please answer the same question.
Good evening again, and thank you. With regard to probation and parole, and I'm really, really sorry, that's so young for so many people to go through that for so long. Here's the problem with bail, or excuse me, with probation and parole. People get yanked in on technical difficulties when we already know that the judge, even a common pleas judge, is more likely than not going to lift it. And in the meantime, they can lose their job. They're waiting and waiting and waiting. Now, when somebody has a new case, then again, it's sort of the same situation as it was with bail. Why are you going to lock someone up on a violation or on a detainer hearing when perhaps the case is very de minimis, or there really is not a threat to the community? When you're talking about a direct violation, again, a person is presumed innocent. And you can't just drop a detainer on somebody because they caught a new case without knowing more about it. And I think that this needs to be worked out in part with the probation, adult probation and parole department. Particularly at my level, it would be mostly misdemeanors. At least initially, all of mine would be. The DAs do sometimes try an F1, felony 1, drug sale or manufacturing in front of municipal court judges. So probation and parole seriously needs to be revamped. And the system with regard to dropping detainers on people and keeping people incarcerated where they do miss their children, they miss funerals, they miss jobs, they lose out on a job because maybe they're held too long, needs to be entirely revamped and needs to be reviewed again on a case-by-case basis if it's something very, very serious, like one of the very hard felonies and the cases are there. But that's not something that's going to come before me as a municipal court judge. I'm going to have MC cases.
Rania Major, thank you very much. Thank you for answering the question. George Twerdy, please answer the same question. And I want to remind folks to mute yourself if you are not the speaker. Thank you.
Yeah, one of the dilemmas regarding the probation issue is that, you know, as a judge, I would, at least me personally, it's a much easier thing if someone is convicted of a crime to place that person on probation rather than incarcerate them. The combination of both being incarcerated and long probation certainly does lead people to not be able to get out of the snowball effect of the problem. Violations of probation and things like that, they'll come back before the judge that sentenced that person. And that judge that sentenced that person is hopefully vetted by the community like we're doing now, and will understand what's a true violation and what isn't, and whether it's worthy of some further punishment. But I believe too, what Rania had to say is that where the big problem is when there's a violation or perhaps an overzealous probation officer or a technical violation that occurs in another county. And the person's held for quite a period of time until the probation officer is brought in, all the facts of the violation, and it's heard before the court. And meanwhile, that person could be off the street and in custody. So, you know, that's a problem. Perhaps technology that we're learning from the pandemic can help accelerate that and remove that. As a municipal court judge, I have a limited jurisdiction, and that's the position that I'm running for. So our extent of maximum penalty.
George Twerdy, I want to thank you for your answer. Thank you, George Twerdy. And Maurice Houston, would you answer the same question, please? Maurice Houston.
First, I want to start off by saying that I believe probation and parole should be reasonable. We can't continue to hold a sword of Damocles over someone's head with the expectation that if it is a long tail, there's a possibility that they're not going to make it. We're talking around the subject this evening, but now what we're really discussing is the business side of the legal system. I want you to think about that for a minute. And what do I actually mean by that is because we've tried in this country to incarcerate our way out of some of the social problems that are presented before us. And here with this unreasonable probation or unreasonable length of time with parole, that's really what we're talking about today. If we're serious about giving individuals a second chance, then we need to make sure that during this time period, the judge should make recommendations that, one, they go and, if necessary, get drug and alcohol counseling. If there is a mental illness that we discover, go ahead and let's make sure that they get the treatment that they need, job training, bring them back in, and use that time period for something that is productive versus non-productive activity, asking people to just hold them over the jurisdiction of the court just to wait and see. Studies have shown that that is unreasonable, it's not fair, and there's a high possibility of recidivism because of the time frame that we're asking them to report to the court. So we need to think about that. This is one of those things where we need to push our legislatures, Pennsylvania
10
legislatures,
seconds.
to change the law.
Tiva, you're muted.
That happens. Tamika Washington, would you answer the same question? Thank you for your patience.
Well, we could take a view of other states, for example, Georgia, which has the highest number of adults under probational control in the nation. Pennsylvania is second, has actually had its numbers be reduced by making sure that if a person only has fines and they're complying in other ways, then that person can qualify to have their probation reduced. Additionally, we can start out with, for example, the state of Michigan, they have more diversion programs. There are diversion programs right in the city of Philadelphia, such as Philadelphia Treatment Court, which has been hailed all over the country. There's Dawn's Court, and those are just the beginning. I mean, we have job training programs right here in the city again. We have a number of programs that as if I become judge, that I would be able to say, hey, does this person qualify for these diversion programs? These programs that can alleviate why that person was even imprisoned in the first place. So the issue is probation, but there are a number of things that we can do even before we get to that. And of course, once a person is, with regard to the time frame of probation, 5 years, I do not agree with the length of time, particularly where it's a de minimis crime. So.
Thank you, Tamika Washington. That was Tamika Washington. Thank you very much. Thanks again for your patience while I unmuted myself. Kateria McCabe, please answer the question, and thank you for your patience. Kateria McCabe. Yeah, no, I'm not muted now.
She left. I think she might be back later.
Okay. So thank you. We just heard, and I want to just ask Jamie Sullivan. I want to say to Jamie, thank you again for your question. It was very important. According to the Philadelphia Inquirer, 1 in 23 adults in Philadelphia are on probation or parole, which is the highest rate of any big city. Pennsylvania is also one of the leading states in long probation tails, sentencing many people to probation for 10 years or more after a jail sentence. The question was, what would you do to curb Philadelphia's problem with mass supervision? So.
Tiba,
now-
excuse me, I'm sorry. This is candidate Nick Kamau.
No, Nick, stop. No, that's not happening. So we are now moving on to our artist performance, and that would be Nick Lopez Rodriguez, Boricua, poet, writer, professor, Brewhex, and DJ. Please welcome Nick Lopez Rodriguez.
Thank you, T-Bob, for the introductions. Can everyone hear me okay?
Yes.
Perfect, perfect. I always like to do a quick temperature check to make sure folks can hear me. I'm not going to spend too much time introducing this piece. I just want to get straight into the poem. I want to just say, though, as a caveat, we are in this new Zoom universe, so do expect there will be some technical difficulties. If it happens that I break up, let blow on the cartridge a little bit and let the computer sort of recalibrate, and I promise I will get back on. I've been an organizer now for over 15 years, doing a lot of my work primarily in the city of Philadelphia, but I'm also a writer and an artist. And oftentimes I think about what are the ways in which writing and creative writing and art can be used as a tool to effectuate social change. And so I think back to a conversation that I had with one of my mentors, who was also an organizer and who was also a writer. And he told me that history tells folks what happened. Poetry tells you how the people felt. So the piece I want to share tonight, I hope in some ways can share what our community is feeling now in Philadelphia and what our communities across the country are feeling. This piece is called America Beloved. Part 1. I'm from a city where police killed Niza Morris and for 17 years have kept their murder a secret. I'm from a city where I watched developers suffocate in white paint the mural of one of our own fallen historical legacies. How many times a day are you reminded that they don't care? All my life, I've wanted to wake up from this death slumber, wash dishes with the windows open, blasting Hector Lavoe, find love walking in any street and not be accosted. Instead, I toss awake, run my fingers through my hair, choose which clothes will earn the least amount of stares, and slip my existence into an envelope. I hope my discomfort will comfort most into being quiet. America, love is not sending prayer circles to change my personhood. Care does not come with a refusal to see me as what I am. When I walk down the street, I want bystanders to blush at the insistence of my simple being me that earns plentiful praise, or simply just walk next to people with love that isn't based on the ways we choose what matter. And isn't that always the project of America? Always deciding which people matter, knowing it is never you nor me. America, you ever got a GoFundMe donation and had to take that as justice? You ever had to picket sign in front of a camera and a headlight to make sure you don't get snatched? You ever went to a restroom and didn't know if you would come out breathing? You ever been to the places that she been, that I been, they been, we been? You ever been, felt, lived a life that includes safety? All my good sisters look just like Niza or Brianna or Vanessa. So goddamn beautiful. And in goddamn America, all prone to death too. Is staying alive just another phrase for liberation? Part 2. It was always summertime. Mornings after gunshots, moms gathered tugging grandchildren to whisper in Spanish names of sons until their prayers collapsed like bones underneath a suffering one of us could know how to carry. They cried in the small rooms their palms turned out to be. Grandchildren asked for a few dollars for when the ice cream man came. Around the city, everyone wore the dead boy on t-shirts where he lived in a photograph on his bike, his hand raising a P. Even in death, we rep the hood. His daughter was at the car wash fundraiser for his funeral. She smiled with a super pop. Father pulsed against her chest, a brave lie. So many candles were placed against the fence of where he fell. A burning city. No one could reach the sidewalk. People in the street became disillusion's parade. I thought, what I know is death makes us neighbors again, and that funerals look too much like family reunions. America, what is the appropriate response to watching someone murdered should not be a question children learn to answer in conviction. At every sound of death, the world shrank around us. We punched the walls to open it back up. We emptied beer cans after funerals. Naima kept talking her shit. Keep up, bitches, she yelled, until we were all singing in Spanish. Me too. Life was a dirge. I wanted to go home, but I was there. Someone passed around a blunt. I was happier with smoke waving from between my lips. How do you laugh through a mask? America, what do you want to say? If liberation, according to Webster, is to be liberated from oppression and freedom from limits on thoughts or behaviors, it means that America, I'm not really free, am I? I wrote that last line to light a fire. What I mean is I don't believe men with ladders are coming to save me. What I mean is nothing makes me feel as close to liberation as seeing people out for their city. How every move is one made in the direction of the lock on their chains. Freedom by any means. Every breath, a chance at turning the key toward the sky unlocked. Limits existing everywhere else, not here. Part 3. America, I've been wondering lately. You seem filled with violent people who like causing people pain, but hate when those people tell you that pain hurts. America, you always ask for an encore just so you can throw flowers in death. America, you say nothing is free and lasts forever. So for today, even if just today, I'm deliberate and afraid of nothing. Ritualizing in whispered promises and saging of rooms in which we do not promise what we will do, and we do not promise what we will never do again. We promise what we are. Of all the metamorphoses, I can never remember what people turn into, but why? May I never remember reasons for my spirit's need for safety. May I never forget the warning of my body's flesh weeping at the new moon. May I never lose that terror that keeps me brave. May I owe nothing that I cannot repay. May I give my lungs pardon for willing me this far. I shall be forever. Thank you everyone for allowing me to be part of this space. And thank you to the organizers and all the community members here who hopefully will tell these judicial candidates the feelings of the people and why this role and this responsibility matters. Thank you, everyone.
Thank you, Nick Lopez Rodriguez. Thank you so much. So we are going to continue with the open-ended questions for the evening. The next one is around family court, and we have someone from the Working Families Organization, Ernest Bannister, with our question, and these are the last 3 questions. This one is with family court. Ernest?
Yes, good evening, everyone. To the candidates, I have a 2-part question. A 2019 report from the National Coalition for Child Protection Reform identified lack of housing as a factor in 11% of removals of children in Philadelphia, and noted that poverty factors into an even higher percentage of removals. Question 1, how would you ensure that you are not terminating parental rights because of poverty? And 2, what would you do in place of terminating parental rights?
Okay, and Ernest Bannister, thank you. We're gonna start off with Tamika Washington, please. Tamika Washington, would you answer the question?
Can you all hear me?
Yes, yes, we can. Thank you.
What I would do to make sure that, well, no, I would not terminate parental rights because of poverty. Housing should not be a factor with regard to termination of parental rights. While it can be a temporary issue with regard to finding a child a place to stay, it is not something that should require rights to be terminated. What the factors are is whether or not that parent has made efforts for the last 6 months to be to maintain a relationship with the child. Has that parent gone above and beyond to make sure that that relationship with the child is there, and has the parent done all that they needed to do? With regard to what I would do to make sure that housing is not, or poverty is not a reason for rights to be terminated is, well, in my courtroom, I would understand that first, what I've just stated, that first of all, there's a fact, there's a set of facts before me that that child and that parent has been before me for a good period of time, or I would have seen the file and seen what efforts did that parent make over the course of, say, 2 years that this case has been in court, a significant amount of time. What has there been mental health counseling? Has there been other parental objectives that that parent has complied with? So housing in itself cannot be a reason to terminate parental rights forever. There's a bond between a parent and a child.
Tamika Washington, thank you for your answer. That was Tamika Washington. Rania Major, would you answer the same question? Rania Major.
I don't think she's back yet.
Okay. Well, Maurice Houston, would you answer the same question and let me know if you need to hear it again?
No, I think I'm comfortable answering the question. My response to question number one, would I terminate parental rights because of poverty? No. With respect to the second question, I would look at all the factors that are relevant factors, keeping in mind that we want to use the best interest of the child as the standard. Now, with respect to poverty, you think about custody and you think about child support. The two are mutually exclusive. And what we do know is if we're trying to build better men or better women, they need to have a relationship with both parents if it's a possibility. So what we have to think about here in this particular case is just because someone is poor, that doesn't mean that they're not going to be a good parent. Just because someone is homeless, that doesn't mean they're not going to be a good parent. Those are temporary circumstances. And with temporary circumstances, those are just temporary conditions. So again, poverty, all of us can fall into hard financial times, but it's important that we respect the relationship between a parent and child and give every parent an opportunity to play a role in the rearing of those children. And keeping in mind that the best standard of the child is the standard that we use the guidelines that the courts have in front of us, but make sure that we can tailor those guidelines to help parents who are interested in serving in those roles. Thank you.
Thank you. That was Maurice Houston. Thank you. Rania Major, are you here with us to answer the question? And do you need the question repeated? I thought I saw Rania. Okay.
Yes, please. Can you repeat it? And I'm sorry, I missed the rest of the poem.
No, well,
No problem.
this is being recorded, so you'll be able to see it again. How would you ensure that you are not terminating parental rights because of poverty? And what would you do in place of terminating parental rights?
First of all, that's not an issue that I, as a municipal court judge, would be dealing with, but so that you understand my philosophy, here's what I would do. I represent people pro bono in DHS dependency cases. I have represented at least 5 people for the last 4 or 5 years pro bono at a single time, because poverty should not prevent them from having a good attorney, and nor should it prevent them from getting their children back. Poverty is not the gauge. People can love, people can give, and maybe some can give you more economically, but that doesn't mean that somebody else doesn't love you as much or wouldn't care for you as much. And the dependency system also needs some serious revamping. Our DHS caseworkers, to some extent, need some serious revamping. Some of them are better than others. Some of them don't listen to a parent. And when somebody is poor and they need to take all of these classes and they can't even afford to take the class so that they can work on what DHS or the court wants them to do to try to get their child back, then it should be supplemented somehow. It should be given to them free. And just like anything else where you have filing fees and you can file what's called an informa pauperis petition, then let that person basically be informa pauperis for purposes of taking the classes that are required to try to get their child back. And if they are indeed a really, really bad parent and they don't deserve to have the child back, that would come out. But don't do it because they're economically disadvantaged and can't take the classes and get the support that they need, which is what our system has been doing. Well, that's what our system has been doing. And nothing should be gauged just based upon economics. And sometimes it's those people that need help the most.
Okay. Thank you, Rania Major. That was Rania Major. And the same question applies now to George Twardy. George Twardy, please answer the same question.
Yes, I would. Well, first of all, I'd echo the same remarks as all those who've just answered the question before me. I also am running for municipal court, and it would not be a matter that I would address. However, I currently sit as a Court of Common Pleas judge in the family court, and I hear custody cases. And I can tell you unequivocally, poverty and housing would not be a factor that I would consider in terminating terminating a parent's rights to their child, to have their child. Certainly, housing, instability of housing is an issue regarding the child, but we would explore family members. Who else could help out temporarily? But that would not be an issue and certainly as there are programs to help a mother or a father who is having housing problems to find housing and get additional support pending the stabilization of that housing. So, I mean, the answer to the question, no, that would not be a factor that I would consider in terminating a parent's rights.
George, did you want to follow through with the last part of that question? What would you do in place of terminating parental rights?
Well, I did. I said that I would, as I do, as a custody judge, as a judge hearing custody matters. If there's I try to explore what other family members there are to help in a temporary basis until one of the parents finds
10
it.
seconds.
And thank you, George Twardy. So same question for Dan Solomon. Dan Solomon.
Okay, we're talking about dependency cases. I'm a family court judge. I hear domestic relations cases. been in family court for 20 years. The first thing you should know is that judges are responsible for the safety and well-being of every child that comes in there. The purpose of a dependency case should not necessarily to be remove a child or terminate a parent's rights. The first goal is to see if that child can be reunited with a family member to keep that family together. So when children enter the foster care system or they're moved around from place to place, this is life-altering trauma. And courts should be very, very careful about removing children from their home. It should be only for the most extreme cases. Or you're talking cases where, you know, children have been severely physically abused and their lives are in danger. Secondly, foster care is not the best option. As Judge Twardy stated, you want to pursue appropriate family members until the situation can be rectified. Also, what's important to know is the government is involved in these cases. It's the Department of Human Services coming in, filing a petition asking for removal or asking for services. So the court has the obligation to properly monitor what the DHS social workers are doing, whether they're following up appropriately, whether they're finding resources that the department has for families to stay together, whether that's housing or job training or drug treatment. It's the judge has to be very involved in the case to make sure the government is doing its job. You know, removal and termination.
10 seconds.
So I'll just say the court should ensure safety to children, and poverty shouldn't be a factor in determining whether they should be removed or not.
Okay. Thank you, Dan Solomon. That was Dan Solomon. Caroline Turner. Caroline Turner, would you answer the question, the two-part question as well?
Yes, as somebody who was a single mother of 4 children, the stress of poverty is absolutely crippling on people, actually evicting people for poverty. I heard a case the other day, a CLS case, where a woman hadn't been able to pay her heating bills and her 5 kids were taken away from her for a whole year. This is outrageous. We're supposed to be helping support people. We have so many community resources. We need people circling around that family. We need the resources without the poor parents having to jump through all sorts of bureaucratic hoops and be screened. We need to contact the Rapidly Housing Philadelphia or Housing First. We need to put it as a really urgent thing to get that family housed so that they can stay together. You should never take children. I've also endured the pain of family separation through immigration issues, and no family should have to go through that kind of trauma and separation from the one thing that they have, which is a mother or a father who loves them. We need to do so much more to invest in our communities so that we can circle around these families rather than put it all on governmental housing. And we need to use our resources that we have in our communities. In place of terminating parental rights, I would find all the community resources that I know are available, because I've been investigating what resources are available. We have absolutely excellent resources in our communities that we are not using. We're not using them as a court, all of them as courts right now, and we need to be.
Thank you, Caroline Turner. That was Caroline Turner. And before we go to Katia, just want to double check to see if Kateria McCabe is here to answer the question.
No, I think Kateria McCabe left. And also, just to let folks know, there's like other forums going on at the same time right now. And I know a lot of candidates did let us know that they're basically juggling between all of them. So that's happening. Yeah, but thanks for checking in.
Thank you, Katia. Take it away. Katia is going to clarify around our next question for municipal court candidates only.
Oh, no. I was just going to just give an update on Nick Kamal. So basically there was miscommunication and he was told by his campaign manager that he was speaking today and presenting today. That's why he tried to speak. So I was just giving folks that clarification. He let me know that there was miscommunication and that he was told that he was supposed to be on today. But yeah, I think it's Ahmad Mitchell from 1PA that's up for the question.
Yes. Okay. Thank you, Katia. And Ahmad, you are up. Ahmad Mitchell from 1PA. This is the second to the last question, housing immigration.
Good evening. My question is, what can municipal judges do to ensure that housing court is a place where all Philadelphians, regardless of immigration status, can access justice instead of solely being a tool for the landlords?
So this first person we'll speak to will be Caroline Turner. Can you answer that question? Thank you, Ahmad.
You're muted.
Can you hear me now?
Yes.
You can. I'm not running for municipal court, but I have been actually volunteering with the Good Shepherd mediation program and helping with the mandatory mediation that is required for landlords and tenants at this present time. During COVID especially, it's been a huge problem. Certainly there was a question about immigration too. Again, I have experienced very drastic, awful, evil effects of immigration, targeting people who do not have full citizenship status in this country. And landlords have very much taken advantage of reporting people who don't have their documentation to the authorities. They've charged them excessive rents. They have really taken advantage of the situation, and it's simply not acceptable. So I don't know if there was a second part to that question, but I am not running for municipal court, so I didn't write that one down. So could somebody repeat it, please?
Caroline, thank you so much. This question was for George Torrey. That was my mistake.
Oh.
Thank you very much for answering it anyway. George Torrey, thank you for your patience. And would you please answer the question now? Thank you, Caroline.
Thank you.
I please have the question restated. I got a little confused after hearing.
Yes, after my big.
No, not you.
So Ahmad, did you want to pose the question again?
Yes. The question is, what can municipal judges do to ensure that housing court is a place where all people, regardless of immigration status, can go for justice instead of being a tool solely for landlords?
Thank you, Ahmad.
Okay, well, I mean, first of all, as an attorney for over 30 years and now as a judge, I've represented many people, and as a judge, I've heard, and my office here is for 30 years has been in the Center City and the Chinatown section. So many of my clients were throughout the years undocumented. And didn't speak the language. I've always done everything I could as an attorney to make sure that they were treated fairly and their rights as anyone else in this country were upheld and given full force and effect. As a judge, I hear, and especially particularly now in custody court, most of my cases are from people that are unrepresented. So what do I do as a judge? Well, in that instance, and sometimes there's a party that is represented and the other party isn't. I try to level the playing field as a judge and make sure that either party, the unrepresented party, is not taken advantage of. That if they are unprepared because they simply don't know how to present a case, that they be given an opportunity to get the things they can to show me that support their allegations. So being fair, being patient, listening to people, and understanding that they're not all lawyers and their immigration status means nothing to me. why they appear before me regarding a landlord-tenant matter. There's either there's a contract, there's
10 seconds.
disputes, and I will hear those disputes, and there's valid arguments on tenant's behalf as well. So.
George Torrey, thank you for answering the question, our municipal court candidate. And we want to take this opportunity to allow the other candidates to answer, even though they are not running for municipal court, if they're interested in running. Dan Solomon, would you like to answer this question?
Sure. I've been a family court judge for a total of 3 years. I have 20 years of experience hearing cases with all different kinds of people. Largely 80 to 90% are not represented. What the court can do, and Judge Torrey alluded to it, was that the court really has to be impartial and fair. If a certain sort of party is always represented and a certain sort of party is always not, you have to make sure that that unrepresented party is getting a fair shake. They're not being bullied. They're not being run over because somebody has the ability to have an attorney, where somebody who might be in a situation where they're getting evicted clearly doesn't have the money to hire an attorney. What the city of Philadelphia has done, and the Bar Association was supportive of, was getting funding for tenants who were faced with eviction cases. So that's a good thing. But the court needs to promote that, promote mediation in those cases, and promote alternative dispositions, so that not 99% of the cases are default and judgments in favor of plaintiffs in those cases, which the vast majority are. So everything needs to be level, and we need judges on the court who are able to not be bullied just because somebody has an attorney. And I've got a long record of hearing cases of unrepresented people and making appropriate and fair and compassionate decisions. So I would do that in a landlord-tenant case. I probably won't be there, but I'll do that in your family court case as well.
Thank you, Dan. Dan Solomon. So next question, same question, Tamika Washington, if you care to answer.
Yes, hi, can you hear me?
I sure can, thank you.
So in any case where a person is unrepresented, the judge has to just be patient with the person who is unrepresented. In some cases, yes, it's tenants. In some cases, it's landlords. In most of the cases in municipal court where it's a landlord tenant, yes, most of the time the tenants are unrepresented. So I would, if I were sitting in municipal court, I would certainly just take the time to be patient, make sure that everyone who comes before me would know that I've listened to them, that I haven't allowed the person who has an attorney to just bulldoze the entire case, but that I've listened to them, and that I've actually found out some background, looked at the contracts, and make the contract in the case, make sure I've looked at everything in that case. So certainly in immigration status, that means absolutely nothing. It's two people that stand before me. So that's not an issue that I would have. Thank you.
Thank you, Tamika Washington. Rania Major, I'm sorry, would you also care to answer the question?
First of all, I am running for municipal court. So yes, that's okay.
My apologies.
No problem. You still have me down for both, so I can understand the confusion, but no problem. But I do landlord-tenant matters, okay? First of all, they do have an attorney, one now, that helps people pro bono. Given the number of people that go through landlord-tenant court, there needs to be more than one. Additionally, again, this goes back to the ICE question earlier. The immigrants who are being brought by landlords trying to take advantage of them, who don't want to show up because they're afraid that ICE could show up. That's where we need the protections, okay? What we do need and what we can do is we can make videos accessible by internet or by telephone. Most people at least have a telephone. We can also make them available in the building in different languages. Okay, the building is now, or the court is bilingual, obviously in Spanish all the time, but any other language can be called on the phone, whether it's Vietnamese or Chinese or Russian or whatever it might be, so everybody has access. If we put in the building so that people know they can go ahead of time and try to help read up to what they need to do and how to protect themselves. How do they escrow money if they do have the rent, but they're holding it back because their landlord isn't giving them heat and taking advantage of them? How do they fit to all the protocols? So they need access that way. But we also, the money that Dan just spoke about, that money has been sitting there for volunteers for a very long time. It's very much like in criminal law where you can be a court appointed, you get
10 seconds.
court appointed for landlord tenant, and it's not being used. And by the way, the moratorium got extended again today until the 30th of June. And people are going to be lost without us helping them try.
Thank you.
Rania Major, thank you. Rania Major is running for municipal court as well. Thank you again for your patience, Rania Major. And last but not least, Maurice Houston, would you care to answer the same question?
Certainly. I echo some of the sentiments that we heard earlier, but immigration status is not paramount to what's going on in landlord-tenant court. When you're thinking of someone who's representing themselves pro se, it's important that the court is sensitive to the facts that they may not be familiar with the procedural rules. And that's an opportunity for the court to assist those pro se litigants to ensure that notice to the tenant was actually given in the time frame that is required under the rules. So again, that's a sensitive subject, especially for individuals who were renters or no longer renters, but you understand the process with landlord-tenant court, and it's important that we use the mediation process that is available for landlords and tenants to make sure that no one is running roughshod over someone because they are unfamiliar with the rules. And with respect to immigration law coming into play, I think we have to be sensitive and careful that we're not allowing individuals to continue to victimize someone because of their status. So I think we need to ensure that we tell folks that you're entitled to come into the court. Everyone is entitled to come into the court and have their say. Thank you.
Maurice Houston, thank you, Maurice Houston, for answering the question. We are now moving on to the final question of the day. It is values and trauma. This question comes from Youth Art and Self-Empowerment Project, and this would be Will Bentley. Will?
How everybody doing tonight? Can y'all hear me?
Yes, Will, we can hear you. Thank you.
How y'all doing? My name is William Bentley. I'm a youth organizer with the Youth Art Self-Empowerment Project and the Philadelphia Community Bail Fund. 6 years ago as a kid, I was judged inside the Philadelphia courtrooms for a second glance at who I am. This is me. I might not look like it, but I grew up poor. Sometimes we had no hot water, no lights, no heat. My house was heated by the electrical stove that kicked out when the lights were shut off. Most of my stuff was passed on from older siblings and cousins. I grew up fatherless and sometimes motherless. I asked God millions of times, what did I do to live like this? I lost over 30 plus friends to gun violence to the point I lost count, to be honest. I never knew what mental health was. I was 14 and being poor, I never had access to mental health treatment. I was 14 charged with armed robbery, facing 20 to 40 years for a dumb decision because I was hungry, because I wanted nice things, or maybe because I was tired of living how I was. What do I tell my younger siblings who were just as hungry as me, with their stomachs sounding like the monsters under the bed? I was tired of going to school with no clean clothes. I want judges to give kids second chances, to give people a chance. I'm so thankful I didn't serve 20 years of state. With the help of the Philadelphia Community Bail Fund and the Youth Participatory Defense Hub, I was able to show the courts who I am. Do y'all agree that the root cause of advisory is tied to physical and mental health, prolonged trauma, and poverty? If so, how will you address this in your courtroom?
Well, thank you so much for your story. We appreciate you speaking tonight. I'm going to repeat the question. It's a very important question. And Will, I really appreciate how you framed it. Do you agree that the root cause of adversity is tied to physical and mental illnesses, prolonged trauma, and poverty? If so, how will you address this in your courtroom? We're going to start with Tamika Washington. Tamika.
Yes, I believe that poverty, trauma has definitely caused adversity. I would say 90 to 95% of the cases where there's trauma, mental health issues has caused these issues. As an attorney that used to work at the Department of Human Services, and also as an attorney who has advocated for children to have better homes and for parents to have custody of their children when their children were wrongfully taken by the Department of Human Services, I understand that trauma definitely has an impact on these children for generations. How would I address it in the courtroom? There are a number of programs, mental health programs. There are a number of resources that are right in the city of Philadelphia. There are homelessness resources. There are mental health resources. And I would make sure to seek them out and make sure that if a person qualifies for that, then inquire as to whether that person can receive those services, as opposed to, for example, if that person is in front of me for a criminal, is alleged of a crime, there are other things that we can look at to see, instead of putting that person in prison, are there mental health diversion programs? Are there other drug and alcohol diversion programs? We have to stop the cycle of imprisonment, probation, the revolving door. We have to stop.
10 seconds.
And so we have to look at the key root causes of these kinds of issues in our society. Thank you.
Thank you, Tamika Washington, for your answers. That was Tamika Washington. Do you agree that the root cause of adversity is tied to physical and mental illnesses, prolonged trauma, and poverty? If so, how will you address this in your courtroom, Maurice Houston? Maurice Houston, how will you address this in your courtroom?
I believe that trauma is a relevant factor that should be considered by the court with respect to whether or not it's an aggravating or mitigating circumstance. It's important that we take into consideration all relevant factors. Trauma is a relevant factor. Poverty is a relevant factor. Homelessness is a relevant factor in certain circumstances. It's important that, one, when you're discussing potential plea agreements, recognize that if someone has either a mental illness, that we get them the help that they need. That's one of the things that the courts can recommend as part of any sentence the court meets out, recommending that someone receive mental health assistance. Also, we can make sure that, or at least recommend as a judge, that family members also possibly need to be treated for trauma. I think it's a holistic approach that I would really like to take to ensure that when you're talking about trauma in an individual, let's get to the root cause of the matter so that we can reduce recidivism. So I think trauma should be considered as one of the relevant factors when considering someone coming before the court. Thank you.
Thank you, Maurice Houston. That was Maurice Houston. Thank you for your answer. And do you agree that the root cause of adversity is tied to physical and mental illnesses, prolonged trauma, and poverty? If so, how will you address this in your courtroom, Rania Major?
Thank you. And William, congratulations, by the way. You really did great. So as an attorney, you might come to me for a criminal case or a family law case or a landlord-tenant case, but if you have problems in other areas of your life, I'm going to fix them. And I don't see being a judge as any different. Common Pleas Court has mental health court. Municipal court does not. over 50% of the people that pass through the court system are people with some of the needs that you have just listed. And there's no reason to not use non-court sanctioned programs and different avenues for getting them treatment and understanding their needs. And people need that from the jump. Besides a law degree, I have a psychology degree, undergrad only. I never got to go higher. But you have to look at the whole person and try to help them to help prevent recidivism, to help them understand. Maybe they don't understand the consequences of what they did. And how can you sanction somebody or sentence somebody in that circumstance? You can't. And so as an MC judge, I would hope to bring it down to the MC level. We need some form of mental health court. We need some form of court that also deals with trauma-based issues. There are plenty of ways that people can get help and assistance. And the key, though, is encouraging the attorneys to bring it up earlier and not just at the time of sentencing. Because when I have a client, the judges are going to know up front what's going on with my client. And a lot of lawyers don't practice that way. And you have to work the back end and the front end. So I would be looking for that. I'm very sensitive to those issues. And I'm sensitive particularly to people with different types of BV.
Rania Major, thank you for your answer. Rania Major, do you agree that the root cause of adversity is tied to physical and mental illnesses, prolonged trauma, and poverty? If so, how will you address this in your courtroom? George Twardy.
Okay, well, yes, those factors are important in the courtroom, whether it's a civil courtroom or a criminal courtroom. Unfortunately, in the criminal courtroom, in most instances, you won't learn about those factors except for after a conviction. And frankly, I would take into consideration some of those factors, and I think they might be relevant in a criminal matter, to know that beforehand in coming to my decision as to after all the evidence as to where I would come down and how I would decide things. Because people react. I mean, the law is all factual, and people react differently, and there are different set of facts and different outcome and different determinations. In civil cases, I see it a lot in custody matters. The issue is whether or not that background and that past is going to be harmful to the child. Sometimes you have to order mental health assessment. Sometimes in order to encourage custody, you have families go through certain counseling, and you help them find them just like you were their lawyer. And you get the counsel on both sides to agree, and then you keep the case and you come back and see how it's working. And you're hoping that the person that needs that kind of counseling is actually participating and trying to make it useful. So certainly it would be in criminal matters important regarding my ultimate decision and sentence. And what to do, because I would look at it in terms of restorative type justice.
10 seconds.
And that would be a relevant factor for that. Thank you.
Thank you, George Twardy. That was George Twardy. Thank you for your answer. Do you agree that the root cause of adversity is tied to physical and mental illnesses, prolonged trauma, and poverty? If so, how will you address this in your courtroom? Dan Solomon.
Okay, thank you. Will, thank you for sharing that. Very powerful story. First, I want to say I come at from a family court perspective. And the first thing that a judge should understand is, and I've tried very hard to do this, is you should accord people appropriate respect and dignity. People are coming into family court. A lot of them have serious issues that lead them there. And you have to understand that, and you have to address their issues and their families compassionately. In a family court, a custody court setting, I have the ability, not only for the adults, but for the children, I can order mental health treatment. I can order substance abuse treatment. We can send people to job programs and support cases. We can order reunification therapy. So it's a court where you're trying to repair things in a sense, and you should understand, or at least try to understand, what these families and these children have come through, what they've experienced in life that got them to the point where they're standing before you. And how do you treat them? How do you show the appropriate compassion? How do you show them that their life, their family is as important as yours? So those are the kind of things I would do. And I have a lot of experience in custody cases, domestic violence cases doing that. And I'd like to say that I try to place myself in another person's shoes before I make a decision that's going to impact them and their child's lives indefinitely. So we would use all the resources of mental health, substance abuse, reunification, and jobs program for persons who are in need of it, and for persons who would benefit from that, not only themselves, but their
10
children.
seconds.
Thank you.
Thank you, Dan Solomon. That was Dan Solomon answering the question. Do you agree that the root cause of adversity is tied to physical and mental illnesses, prolonged trauma, and poverty? If so, how will you address this in your courtroom? Mark Moore.
Good evening. Thank you very much. I'm on the bench now. I'm assigned to criminal court. I deal with this all the time. I'm always trying to look for as many social services and programs as I can to try to restore individuals. One of the things that I'm doing on my own is I've assigned individuals who are on my probation to read a book called As a Man Thinketh. It's a 23-page paperback book. It's very simple, but it's trying to get individuals to change the way they think. As Carter G. Woodson, I believe, said, if you can control a man's thinking, you can control a man's actions. What I'm hoping to do is try to get individuals to think differently. You know, in addition to the social services, I mean, things that we haven't even mentioned, there's parenting classes, there's anger management. I was even trying to see, do we have some tutoring classes for individuals? One of the things I would like to add as another layer on that adversity onion is lack of education. I mean, that's crucial. When I have a number of individuals who haven't even finished like 10th grade, you know, and because their school systems, they're not where they need to be, especially for students of color. So to me, one of the things I can do is try to get individuals, finish your education, go back to get the GED, in addition to mental health, drug abuse, drug, alcohol addiction services. A number of them don't need mental health services, but they need other services, again, like parenting classes. That's huge. Anger management. Anything that I can do currently to help them push them on a path to betterness, I'm going to do it. I would love to have more social services. I would love to have more job training programs, because a number of these individuals are highly skilled. It's just that they just don't have an opportunity, you know, to go do it. So I'm always trying to look for as many social services as I can to address that adversity.
10 seconds.
The results of long-term trauma, adversity, poverty, and lack of education.
Thank you, Mark Moore. That was Mark Moore answering Will Bentley's question. The question is, again, do you agree that the root cause of adversity is tied to physical and mental illnesses, prolonged trauma, and poverty? If so, how will you address this in your courtroom? Kateria McKay, please answer this question.
The answer is yes. And I sit, as you know, in family court, and I hear the dependency cases of children who've been neglected, abused, or truant. And there's so many factors that play a role in why children are impacted by the dependency system. I use a plethora of resources in addition to the case manager's resources. Because of my experience, I've been practicing law about 30 years, and I have my own resources that I will direct the case managers to try, because we have to wrap our arms around families, address any adverse childhood experiences, address mental illness, address any issues that they may have, so that we can, to the extent as possible, make the families whole. It could be a child is dealing with their sexual identity, so we can reach out to the Mazzoni Center. It could be parents that just don't quite understand. They too can get the counseling that's necessary so that they can be a positive influence on their children, as opposed to having the battles that they may have. It may be family therapy. What I think is very important is that we look holistically at the children, at the parents that come before us, so that we can make a positive impact and instead of having a negative impact with the judicial system.
Thank you, Kateria McCabe. That was Kateria McCabe answering Will Bentley's question. Do you agree that the root cause of adversity is tied to physical and mental illnesses, prolonged trauma, and poverty? If so, how will you address this in your courtroom, Caroline Turner?
You're on mute.
Okay. William, thank you so much for sharing your story. It's a very powerful story. Thank you. I do believe that I was a public defender, and the vast majority of my clients had suffered very prolonged trauma, not just poverty, stigma of mental health issues. Some of my clients had made it through high school, yet could barely read and write because their schools were so poor. We are seeing the results of generational trauma in Black and Brown communities, particularly, where we have overpoliced them. We have taken away the resources that used to be there. Certainly in the last 20 or 30 years, we have done that in an alarming way, and we've built more prisons and we've spent more on police. And a lot of communities are left with very little, except that we have amazing, credible messengers in our communities who, we have people who are formerly incarcerated, like Dear John Thompson, who's on tonight, like Bill Cobb, like Latonya Myers, who are doing everything they can to give to their communities. They're providing resources, whether it's stepping in as a substitute dad, whether it's helping people with their legal cases, whether it's helping people with identity, children with LGBTQ children, and helping people get what they need.
10 seconds.
We have the people in community. We need to use them. We have these shining examples of people who are wanting so badly to give back to their community.
Thank you, Caroline Turner. And we have just answered the last question. I just want to double check with Katia in case there is something that we need to make you aware of before we mention again who all is running for Common Pleas and for municipal court. Katia?
No, that was the last question. Thank you, Tiba, for checking that.
Okay, so again, there are 8 seats open for the Court of Common Pleas. The 17 candidates running for those 8 seats are Caroline Turner, Terry Booker, Wendy Barish, Craig Levin, Kateria McCabe, Sherry Cohen, Nick Kamal, Patrick Moran, Dan Solman, Maurice Houston, Betsy Wall, Michelle Hangley, Richard Cataldi, John Padova, Chris Hall, Mark Moore, and Tamika Washington. The 5 candidates running for the 3 open seats in municipal court are Michael Lambert, Barbara Thompson, George Twardy, Sherry Cohen, Greg Yorgi Gertie, Rania Major. We want to thank you again for attending the Judges Judicial Candidates Forum. And we hope that you have tweeted out as much as you can. You've joined us through Facebook, and we really appreciate having this opportunity to educate. Katia? I know I'm not muted.